Imagine this. You're a shipper with thousands of dollars in freight. You hire a broker to arrange transportation. That broker finds a carrier, but somewhere along the way, disaster strikes. The load is lost, damaged, or worse, someone is hurt. Now here's the big question. Should the broker, the middleman, be the one on the hook for liability? That's exactly what a major court case linked to Total Quality Logistics, or TQL, is asking right now. And depending on how this plays out, it could reshape the entire freight industry. So today we're breaking it down. What's happening in this case, why it matters, and whether it's right for brokers to be held liable. A freight broker doesn't own the trucks. They don't employ the drivers. Their job is to connect shippers who have freight with carriers who can haul it. They're the matchmaker of the supply chain. Traditionally, carriers are the ones responsible if something goes wrong during transport. They're the ones actually moving the goods. But in recent years, lawsuits have tried to pull brokers into the liability chain, arguing they played a role by selecting or vetting the carrier. This all comes back to the Federal Aviation Administration Authorization Act, or FAAAA. Even though it sounds like it's about planes, it also covers trucking. It was designed to prevent states from over-regulating freight, and for years, it's been used as a shield to keep brokers from being dragged into state negligence claims. But not every court agrees on how far that shield goes. Some circuit courts say brokers can't be sued, others say they can. And now, with the TQL case, the Supreme Court is being asked to settle the split. The Transportation Intermediaries Association has stepped in with a warning. They say if courts start holding brokers liable for accidents or losses, it could create an existential threat for smaller brokers, because they'd suddenly be exposed to massive lawsuits in every state they operate in, and most don't have the resources or insurance to survive that. So let's break down both sides. Arguments in favor of broker liability. First, accountability. Brokers are the ones choosing carriers, sometimes with access to safety data, insurance records, and safety ratings. If they book a carrier with a history of problems, shouldn't they bear some responsibility? Second, protection for shippers. If the carrier goes bankrupt, disappears, or doesn't have enough coverage, the broker could provide another avenue to recover damages. And third, deterrence. If brokers know they could be held liable, maybe they'll put more effort into vetting carriers and raising safety standards. Now the arguments against. Brokers don't own trucks or employ drivers. They don't control the actual movement of freight. Holding them liable for something they didn't physically do seems unfair. Insurance costs could skyrocket. Many brokers aren't set up to carry liability coverage for accidents on the road. If they're forced to, smaller firms could be driven out of business. And finally, complexity. Brokers operate across all 50 states. If every state can impose its own liability rules, the patchwork could make it nearly impossible to run a nationwide brokerage. And here's where it gets messy. Different federal appeals courts have reached different conclusions. That's what lawyers call a circuit split. Normally, when this happens, the Supreme Court steps in to make a final ruling so the law is consistent nationwide. But some justices have suggested they want more lower court cases to play out before weighing in. In the meantime, uncertainty reigns. So what would it mean if the Supreme Court sides with broad broker liability? We'd likely see more lawsuits targeting brokers. Insurance costs would rise. Contracts between shippers, carriers, and brokers would need to be rewritten. Big brokers might weather the storm, but smaller ones could be forced to shut down. On the flip side, if the court limits liability, it keeps the current system intact, but doesn't resolve the uncertainty for shippers who feel left out when things go wrong. So here we are at the crossroads. Should brokers, who don't drive the trucks but do choose the carriers, be held responsible when tragedy strikes? Or is that asking too much of the middleman? This case isn't just about TQL. It's about the future of freight liability in America. And the decision could reshape how risk is divided across the entire supply chain. Now, I want to hear from you. Is it right for a broker to be on the hook? Or should liability stop with the carrier? Drop your thoughts in the comments below. Hit that like button, and don't forget to subscribe for more breakdowns like this. Thanks for watching.